invading armies or from dissenters from within who would seek to impose their will on us, from common criminals or those who would take our life or our property by fraud and deceit. They understood you needed the coercive power of the state to protect you. Don't do much else than that. They also appreciated things like the rule of law so that people could be treated fairly and equally amongst each other as they naturally interacted with each other. And with that, they came to the Constitution. We all know how the Revolutionary War turned out. We all know how we came to the Constitutional Convention. I'm sure this is one of the first audiences I've been to where I can say that probably everyone in this room has read this document many times. And so I'll skip ahead to judicial review. Now, we all know the courts are created under Article 3. And I'll briefly read the relevant passage. Article 3, Section 2, the judicial power shall extend to all cases in law and equity arising under this Constitution, the laws of the United States, and treaties made or which shall be made under their authority, to all cases affecting ambassadors, public ministers, and consuls, to all cases of admiralty and maritime jurisdiction, to controversies to which the United States shall be a party, controversies between two or more states, between a state and citizen of another state, between citizens of different states, citizens of the same state claiming land grants of different states, and between a state or a citizen thereof and foreign state citizens and subjects. In all cases affecting ambassadors, other public ministers and consuls, and those in which a state shall be party, the Supreme Court shall have original jurisdiction, meaning they can hear the case before any other court does. In all other cases before mentioned, the Supreme Court shall have appellate jurisdiction, both as to law and fact, with such exceptions and under such regulations that the Congress shall make. In which case, everything else has to go to a lower court first to make a decision, and they simply review the rulings to make sure they're in accordance with the law. And that brings us to Marbury versus Madison, which is where judicial review comes in. And yes, the word judicial review is not in this document. The concept was around. I'll discuss that in a moment. But Marbury versus Madison is where judicial review comes into play as we see it today. Here's the interesting thing. Two things you need to know first. Thomas Jefferson and John Marshall are both cousins. Thomas Jefferson and John Marshall also hate each other's guts with the kind of passion that would make great reality TV today. This is going to be important because this case, believe it or not, was caused because Secretary of State John Marshall screwed up and forgot to do something, leading to a case heard by Chief Justice John Marshall several months later, which led to this review. So it's rather ironic that he is ruling on a screw-up that he himself caused, and largely did it to poke his cousin in the eye because he couldn't stand it very much. So anyways, here's what happens. And this is very similar to what we're seeing today with the lame duck Congress. Back then they called them midnight Congresses. Now we call them lame duck. Basically, John Adams is going out of office. Thomas Jefferson has been elected president, and as a result, John Marshall is going to be out of a job. He's the Secretary of State, which had a lot of domestic duties back in those days. It was more analogous to the Secretary of State of Florida than it is to the Secretary of State in foreign policy that we have today. So they have this midnight Congress, where they change the Judicial Act, create a number of new judges, a number of new justices of the peace, appoint John Marshall to be Chief Justice of the Supreme Court, have the Senate quickly approve it, and then give Jefferson one of these saying, ha ha, you're not president yet. Marshall had the task of taking the commissions that make you a judge. And this isn't a day before you had ID and social security numbers and whatnot. So you would actually get a written commission that says you are a justice of the peace, go forth and do your job. So Mr. Marbury was appointed. He's a Baltimore resident, and he's been appointed by the president, confirmed by the Senate. John Marshall, who for reasons are unclear, never gets around to delivering his commission to him. Thomas Jefferson takes over. James Madison is the Secretary of State. He sees these big stack of commissions that were supposed to be delivered. He asks Jefferson what he wants to do with them, and he says, use them for toilet paper. Never delivers them. Since Marbury cannot be a justice of the peace without this piece of paper, he issues a writ of mandamus and says, please deliver that document to me, I'm entitled to it. That's the background of the case. Goes to court. And under the law, the Judicial Act of 1789 and its sister Judicial Act of 1801, under that it said if you have a problem under this law, you can take it to the Supreme Court. Now, the issue is this, 3 of them. John Marshall says there's 3 issues here. Is there a right? Is there a remedy? And if so, is that remedy available under the Supreme Court and under the Constitution? The answer is this. Yes, there is a right. You are entitled to your commission. Second, yes, you have a remedy of some sort, because if you have a right, you generally always have a remedy unless it's prescribed. The third part, and this is the part you need to pay attention to, is he says, but that said, you're out of luck. Because under the Constitution, Article 3, that passion I just limited to you, states the scope of what we can do. And nowhere in this document does it say that writ of mandamuses for commissions can be heard by the Supreme Court. It says the first important thing, it says this document is a sealing. If it is not before the court, if it is not in this document, we, the Supreme Court, can't hear about it, rule on it, or do anything about it. We can only hear that which is brought before us under the Constitution. This is a huge limit. This is the limiting factor of the Supreme Court. He says that in order for you to deal with this, you'll need to take your case elsewhere. And the fact, and this is the second important point, that the 1789 Judicial Act said if you have a problem, take it to the Supreme Court is invalid. Because Congress can't write a law saying, do this, even if it contradicts the Constitution. He said the law is in conflict. The 1789 Act conflicts with this document. And because there's a conflict, that portion of the law is now null and void. First time judicial review happens. It basically established the principle that this is the premier document over all laws, all treaties, all regulations, anything that Congress and the President promulgate. If it conflicts with this, this document takes precedent, and you can nullify the law. Now, for future reference, it mentions nothing about modifying the law, changing the law, writing new laws, or creating new rights. It just says you can say it is not constitutional and it is nullified.
Is that the entire law or certain portions of it?
There's a very active debate of it. At the time, it was assumed that the relevant portions of the law were nullified. The fact that you could take this to the Supreme Court was nullified. The rest of the Federal Act actually created the Federal Judiciary and the Federal Appellate Court, so that obviously remained. The 1801 Act, the one that created the Marbury's position in the first place, was promptly repealed by Thomas Jefferson, hopefully the way that we repealed the health care law when the new Congress comes in.
Amen.
And there is a good deal of debate on that. Is it whole or is it partial? And frankly, that's done on a case-by-case basis. But the point here is, I'd like to go on, is this created judicial review. And this created the first debate as to whether or not we should have judicial review. The historical record is very simple. Edward Coke, an English barrister, created the concept, or revolutionized the concept in 1610 in a case called Dr. Barnum's case. Basically, he ruled that a guy who's on trial can't be his own judge, odd situation, and nullified the law. And Henry de Becton, who was a great influence on Thomas Jefferson as early as the 12th century, was writing treatises on the notion that laws could be nullified if they conflicted with higher doctrines, such as the Bible or natural law, or the law of the church, or the law of the monarch. So the concept had been around, and even in the Federalist Papers, Alexander Hamilton had written the most prominent argument that was discussed. He said, if it be said that the legislative body are themselves the constitutional judges of their own powers, and the Constitution they put upon them is conclusive upon other departments, it may be answered that this cannot be the natural presumption, where it is not to be collected from any particular provisions of the Constitution. It is not otherwise to be supposed that the Constitution could intend to enable the representatives of the people to substitute their will for that of their constituents. That line, that our representatives cannot substitute their will for their constituents. This document, this was really the codification they were looking at. This was what was discussed throughout history. So this notion of judicial review was present at the time that Marbury versus Madison was heard. And it's the version that has largely been accepted in general terms by the legal community, by the judiciary, by Congress, by the President, and by the United States at large.